right. Well, today I'm going to be talking to you about the public trust doctrine in Wisconsin. Thank you so much for inviting me to come and talk about the law to a group of scientists. You're all very brave to jump out of your disciplines and think, okay, I'm going to pause here and try to learn something new. This is where we're going over the course of the hour. And first I'm going to talk to you about water as a commons and thinking about our different relationships with water. And then I'll talk to you about the public trust doctrine, this legal doctrine, where it comes from and the different concepts, 7 core concepts for Wisconsin. And I'm going to be comparing that to how it's actually being implemented in Wisconsin and describing to you a case study that I did through interviews with Wisconsin Department of Natural Resource staffers and talk about some implications for the commons and recommendations for the future. So we'll start with water as a commons. It's a shared resource that has lots of interlapping rights, and I'm going to show you a huge word first, usufructuary. This is what we refer to in the law as the rights of use in water. So you don't have ownership rights in water, you have usufructuary rights. And water is a shared resource, it's a recycling system. It's so essential for our lives. We drink it, we can't live without it. 70% of irrigated, 70% of the water used in the world is used for irrigated agriculture, so when you're eating food, water is involved in that. Most of you have jeans on, and through this new concept with virtual water, we're able to see how much water it takes to produce the products that we're wearing. So a single pair of jeans, you don't think about water being involved in that, but actually 2,900 gallons of water are used to produce one pair of jeans. So even your clothing involves water. Of course, it's essential for wildlife and keeping the North Woods feeling like the North Woods, essential for navigation and recreation along beaches. Most of our major cities are built on water sources, water courses, and we can't have commerce without water. And then fishing. Fishing is something you guys know probably a heck of a lot more than the average person about, and without clean water we're not able to have fishing. So the legal doctrine that is the basis for protecting water as a commons is called the public trust doctrine. And this is really an ancient doctrine. It's got its roots in Roman law from the 4th century AD. So it's something that isn't a new or novel concept. It actually goes back centuries, many centuries, and many different cultures. And the original concept that the Romans had was that there are certain things that simply cannot be owned. And that includes the shore, fish, water, and the air. And maybe not surprisingly, the English also had the same concept when the King of England was prominent. And it was the idea that the king held all tidal waters in trust for the commoners to use. And something like water, because of its common nature, was seen as incapable of private ownership. So when the United States split from England and became the United States, when the colony split from England, they transported that legal doctrine into the laws of the states in the United States. And when each state entered the Union on what's called equal footing, so each subsequent state came in, they were on equal footing with the original colonies. And they received title to the states, received title to all the navigable waters and the beds beneath them to be held in trust for the public. This was something that happened every time a state was admitted into the Union. And so it's a foundational doctrine. And some people think that it's part of the state's sovereignty and something that a state can never deny or get rid of. This is the Northwest Territory that existed before Wisconsin became a state. You can see it encompasses the area around the Great Lakes. And so even before Wisconsin was a state, it was governed by this Northwest Territory Ordinance, which similarly had all of the waters navigable waters in the territory as forever free and common highways to the public. And that same language was put into Wisconsin's Constitution when we entered the Union as a state. And so that's the origin of what I'm going to be talking about today. And then there are these concepts that are really core to the legal doctrine that you can think about how they maybe play out in contemporary issues. If you have questions about that, feel free to interrupt me, or we can talk after, talk in the space afterwards. I'm going to go through the core concepts to give you the foundation, and you can think about how this plays out in things you might be reading about in paper, or even in the work that you're doing. So, you've probably heard of trust funds. Usually you think about trust funds as some money that's been set aside and to be used for the beneficiary of the trust, and it has to be used in a certain way. Well, the public trust doctrine related to water is very similar. It's like a financial trust where you've got trustees and then you have beneficiaries. All the public are the beneficiaries, and the trust property itself, which is the water and the beds underneath it. So this is the concept that the state is the trustee and has ownership over all of the navigable waters up to the ordinary high water mark. And under rivers, we now have private property owners own the beds of the rivers to the center, but that is always subject to this public trust, what's called a servitude, which is basically a legal easement that makes sure that the public can always access the rivers up to the original demarcation line that was transferred to the state when it entered the Union. So up to the ordinary high water mark on rivers as well. The public should have access to that. This is a really rudimentary drawing of a typical lake, and I'm sure the limnologists are squirming right now. But it shows where the ordinary high water mark is. And so the public lands are down under the water and then up to the ordinary high water mark. At that point, private property starts, unless a city or town owns the uplands. But that's the basics in terms of the ownership. Yes?
Why can people, private citizens, own the stream bottom but not the lake bottom?
Well, it was decided by the courts over 100 years ago that they would divide up the rivers that way, but it actually doesn't have any impact on the public's rights to use the rivers. And so it was just, I think, an easy demarcation line to go to the center of the river, which isn't quite as easy with a lake because you could have cutting up pie shape. Some states do divide up private ownership under lakes as well, but they always have to maintain public rights. Thanks for asking that. So, second concept, that Wisconsin law imposes a duty on the trustees to protect public rights in Wisconsin's navigable waters. This is a really important concept, that there's actually a duty. Well, who has the duty? It's the people in this house. It's in the state capitol. The legislators have a duty that's grounded in the state constitution and was originally reaffirmed in a Milwaukee versus State, a Supreme Court decision in the 1920s, that clearly said the legislature cannot just sit back on its laurels and kind of watch things happen. It has to be an active trustee. It has to take action, positive action, to protect the trust in the water. The legislature has subsequently delegated part of its duty to the Department of Natural Resources. When it created the DNR in 1965, it said, this agency is going to be the primary agency in the state that we delegate some of our trustee duties towards, and they need to generally supervise and manage the waters of the state. And it granted the DNR, quote, all necessary powers. In legal terms, that's giving the agency quite a lot of authority to decide how to protect and carry out its trustee duties. So, does Wisconsin have a water policy? Anyone think so? Kind of all over the map, but we actually do have a statute that established, the legislature established the state water policy, which is very simple. Protect, maintain, and improve the quality and management of the waters of the state. It's very broad. But everything that the state does can be measured against that policy. Is this protecting, maintaining the quality of the waters of the state? It should be used as a benchmark for whether or not the state is carrying out its policy. This should be used. Wisconsin statute 281.11. Write it down if you ever want to hold someone accountable. Okay, core concept number 3. The trustees have a supervisory duty that requires adaptive management. You hear about adaptive management a lot as scientists. This is something that's part of the public trust doctrine. Should riparians rely on prior agency decisions? Sorry for throwing in a legal term there. A riparian is a private property owner who owns land adjacent to a water body. They have riparian water rights, and what they do on their private property impacts the common water. So when the agency makes a decision on issuing them a permit, should that private property owner be able to rely on it? Not if conditions change. I'm going to just focus on the R.W. Docks and Slips case out of Wisconsin rather than the California case. But in that case, the DNR issued a permit to allow a marina and condos to be built on Lake Superior. And after phase 1 of this project, a weed bed emerged that became really good fish habitat. And so when the riparian came back and said, we want the next phase to be permitted, the agency said, no, we need to protect this fish habitat under the public trust doctrine, and our statutes carrying that out. They denied the permit for 71 of the 201 boat slips. And that went all the way up to the Wisconsin Supreme Court, and the court said, that's absolutely right. The DNR is a trustee, and they can review these decisions that they've made previously as conditions have changed in order to carry out their duties to protect and manage the waters of the state. So you never have a right as a riparian that somehow is permanent. It's always shifting with conditions, and it's something that the DNR needs to be engaged in science to continually be informing and updating its decisions and make sure that its decisions are relevant for today. The fourth concept, core concept, is that the public trust doctrine is fluid. It changes over time. It evolves as needed. And this is these are all tied together. But originally we had this definition of navigability that reflected the uses of the water. It was whether or not a water body was capable of floating logs. Well, that's because the water bodies were used for floating logs at the turn of the century when Wisconsin first was becoming a state. And then in the early 1900s, it was changed to recreational. Any water body that was capable of floating a recreational boat any time of the year. So this is kind of a joke, obviously, but really, if you can float a small kayak in a ditch, then it's navigable. And then more recently, this has spilled over the banks of navigability to protect things like shorelands, wetlands that are not navigable, tributaries that aren't navigable, and groundwater. There was a little discussion up here before the talk about groundwater wells drawing down surface water. Well, that is now protected clearly by the public trust doctrine. And the Supreme Court of Wisconsin in the Lake Beulah decision just last year decided that the DNR, when it's issuing a high-capacity well permit for groundwater pumping, has the authority to look at the impacts on surface waters because of this trustee role that it has under the public trust. So the doctrine has now really expanded beyond the original bounds of whether or not a water body can float logs. Similarly, as the public's uses of water and enjoyment of water has changed, what the law protects has changed to reflect that. That's something to really understand about water law, is that it's cultural, and it reflects the norms of the day. So it's always changing to stay relevant to the norms of the day. So historically, water's most important purpose was commerce and navigation when Wisconsin first became a state. But that has changed quite a bit now to cover all sorts of things that people value related to navigation, fishing, recreation, purity, aesthetic, natural beauty, and accessing the water. Those are things that wouldn't have been really thought of when Wisconsin became a state, but the law has evolved to be able to protect the public rights in those things. So something like fishing is a protected public right, boating, putting in a dock, protecting the area for scenic beauty. And what about this, walking along the shores? Do you have the right to walk along the shore of the lake up to the ordinary high water mark? Anyone? Think you do? Yes? Yes? You should. We have a really archaic case from the 20s that said that the private property owner has the exclusive right to use that. That has never been overturned, but it should be if it's challenged today because it's out of step with the rest of the law. Okay, core concept 5, the legislature may grant lakebed title to entities other than the state, but only under limited circumstances. So the primary case on this came out of Illinois. Illinois Central USSC is the United States Supreme Court. And in that case, the Illinois legislature tried to grant and then tried to rescind the grant to most of the Chicago harbor to a private railroad company. And that was seen as beyond the power of the state because this is a grant that would have been wholly private, and the state duty to protect and keep this in trust would have been violated. So grants for purely private purposes are always void. Recognize this? Monona Terrace, okay, that's on lakebed. That was the subject of many years of legal disputes because this is actually a lakebed grant. And the ultimate decision on this in the Wisconsin Supreme Court was that yes, this could be a legitimate use of public trust property because it's owned by the public, it's open to the public, it creates access to the water that wasn't there before. If you guys have been on the bike path or seen people fishing along there. So there are a lot of important factors that really enhance the public nature of this space as opposed to something that completely destroys a lake or privatizes it and keeps the public out. That's in a very different category than the Monona Terrace. But that was heavily disputed. Okay, sixth core concept, that private property, riparian property, must be used in a way that doesn't encroach on public rights and navigable waters. So we have riparian rights. I've already talked about that a little bit. We love these properties. They're right up against the lake. Jake has visited this property on Perch Lake. The riparians have the reasonable use to that water, but that use is always subservient to public rights in the commons. And so we've got these chapters 30 and 31 in state statutes where the DNRs protect public rights when it's issuing permits to riparians to undertake different activities. Do you think there's a difference in perspective between the DNR and the riparian? You know, people want to do what they want to do on their land, right? They don't want to think about the impact, and the DNR is looking out for the whole picture, or they should be. So you get a disconnect when something like this happens, and this person wanted to do what they wanted to do, and they weren't thinking about the impact on the public commons. Or you have, perhaps less dramatically, more common, planting that in Kentucky bluegrass and fertilizing the heck out of it, and impacting not only the public rights in this water body, but the neighboring private property owners who are going to be exposed to the excessive algae. So what happens when things like that occur, when you have this disconnect? That brings us to the seventh and last core concept, that a healthy public trust requires enforcement by the trustees, the DNR. and by the beneficiaries, all of us. You know, we have to be awake and active in this. It doesn't just happen otherwise. So the DNR has broad enforcement authority, of course, and they are supposed to take action when there's an infringement on public rights. Of course, they have discretion about when they take action, and so the beneficiaries also have the ability to step in and enforce the law when something has been violated. And we have statutory authority in Chapter 30 to do that. And we also have a Supreme Court case, the Gilling case, that says that the public can go forward with an enforcement action even if the DNR has decided not to. So we don't just defer to the agency in this. The beneficiaries have the power to enforce their rights in the trust. Yes?
Is this public trust passed from the state to, say, county and city governments? Do they have the same trustee status in any way?
Not really. No, and that gets into kind of a tricky issue because on shoreland zoning, where the agency the DNR has shared authority with the local governments over zoning, it's really important for the trustee, the state trustee, to have supervision and control over that ultimately, to be able to correct a problem if the local government makes a mistake or is swayed by some kind of localized interest. Because the whole concept here is that this is a state resource, and so you need a statewide agency that's looking out for the big picture, the cumulative impacts, rather than having it be controlled by a local entity.
But they often act as trustees or like trustees in protection, for example, in Dane County.
Yes. I mean, county officials can, but it's not covered by this constitutional duty. That's really up to the state legislature and the agency that they have created to have the trustee responsibility. So unless there's a statute that specifically says that the municipality is going to be acting also as a trustee, but with the state overseeing that, I don't think you could just read it in or apply it. Other questions about this? Okay. So we move on to implementation. We've got this great legal doctrine. What's happening with it? I undertook a study where I did qualitative research interviews with almost 2/3 of the DNR water specialists in the state, and they were randomly selected, but I made sure that I had people from all 5 regions of the state. And then I did non-random interviews with top employees like the former DNR secretary, former water division administrator, some of the attorneys and management, upper level management people. So from that, I produced research findings and a law review article that I think has been circulated to this group and certainly is available from my faculty bio if you want to see it. But I identify these systemic factors that constrain the water specialists from carrying out their duties under the public trust doctrine. So there have been tremendous budget cuts at the agency, and those have resulted in, not surprisingly, a reduction in staff to carry out these responsibilities, an increase in geographic area for each staff person to cover. So instead of covering one county, say, you're covering 3 or 4 counties and needing to ride the range a bit more. There's high turnover in this position of the water management specialist because it's a very stressful job and it lacks stable funding. There's also training that has been cut from the budget, which is really a serious and inexpensive thing that needs to be addressed at the agency level, because you're bringing this position is constantly turning over, so you have new people coming in highly contentious kind of interactions with private property owners who want to do what they want to do on their land, and they're not getting, the staffers are not now getting formally trained in how to carry out the different sections of the code, and so they're having to learn a lot on the job, and they're subject to a lot of self-doubt because of that. And there's been a limit on the amount of field work. So the job is really more of a desk job than getting out into the field, just by the nature of having less people covering more area. It has become more computerized. Then there are also some structural factors that have recently limited the agency's ability to carry out its duties as trustee. There's something called Act 118 that created huge exemptions and general permits for many activities that impact water. And they created a system of self-certification by the private property owners, by the riparians, to say, yes, I did everything right, I'm complying with the law, click, and send that in. The DNR secretary appointment is also a structural problem. This is the secretary of the agency used to be appointed by natural resources board, the Natural Resources Board, and now the secretary is appointed by the governor. And that was a change that happened in the mid-90s. My study from a few years ago was a follow-up on a study I'd done 10 years previously. So I've gotten two different points in time here showing how this structural change with the appointment of the head of the agency has really impacted the political influence over the agency's decisions. And in terms of just double back to the Act 118, some of the things that no longer have DNR supervision or permits are like projects in highly urbanized areas. So basically all of Milwaukee County don't have to get permits for those water projects because they're exempt under the law. And then there's permits no longer required for removing topsoil on the banks and navigable streams if it's agricultural. So these are big, when you think about the impact of agriculture on the waterways and creating an exemption that applies to that many participants in this. And that will have broad impacts potentially on the water. And I say potentially because we'll get to that in the end. Back to the political pressure. From the interviews that I did, I saw political pressure coming from the governor's office, the appointees, the top managers, the legislators or their aides regularly calling DNR field staff and pressuring them on permit decisions or enforcement decisions. And this is, if you can imagine yourself in that situation, or some of you do work for the DNR, to have people outside the agency calling you and pressuring you in something that should really be about applying the law and science in an even-handed manner, it creates a lot of undue stress, I think, on the employees. That's what I was getting from the interviews, and I think it leads to some decisions that aren't as even-handed as they should be. Okay, so what does this mean for the water commons? I'm going to talk just briefly, tip of the hat to the late Eleanor Ostrom and her work on the commons. You often hear about the tragedy of the commons, and we need to maybe not have things that are managed as commons because they're subject to abuse. Well, the work of Eleanor Ostrom and her team took the opposite approach and said there are certain factors that need to be present when you have a commons in order to have it managed in a way that's healthy. And I'm not going to do this justice because I'm squeezing it into a few minutes, but I'm going to look at just 3 of the variables that she highlighted as important for having a healthy commons, and then talk about what that means for the Wisconsin's water commons. So the predictability of system dynamics is an important feature when you're dealing with managing the commons. And in my research, I saw that really wasn't present in that the actions, private riparians' actions, they weren't really able to predict how it was going to affect the system. Here's a quote: "An individual may not realize the impact they're having as a single person, but because others start copying the bad behavior, cumulatively it causes harm." And that is really a problem, that when people, you go back to that picture of just this common scene. People do this and they don't think, they think I'm planting grass. You know, I'm clearing my land, I'm gonna have a nice big lawn going up to the water body, and they're not really able to predict what that's gonna do to a common resource. They're not knowledgeable about it. So twisting that around is going to be an important feature if we want to restore the health of the commons, trying to make that more predictable. A second feature here is having shared norms and trust amongst the people who use this common resource. And that's also really a problem that the DNR managers highlighted for me in the interviews. Here's a representative quote. Landowners like these regulations when applied to a neighbor they think is harming shared water, but not when it applies to what they want to do on their land. So, you know, really having a shared water ethic, a shared ethic about how, yes, it's going to restrict what I'm doing on my land, but I can predict what that will do to the commons, and I know that that's a good thing, and we all share these values. You know, so trying to educate people so that there are shared norms and trust is an important factor going forward. The last factor I'm going to touch on here is monitoring and enforcement that Eleanor Ostrom highlighted as being highly important when you have a shared commons, having really clear monitoring and enforcement of provisions. And that's something that's very much lacking in Wisconsin's water commons right now. Enforcement staff have been cut dramatically, and the DNR has a lot of the staffers who I interviewed are doing what they call voluntary enforcement, so they're not going through the formal enforcement channels because it's too onerous and time-consuming, and they're just trying to have these word-of-mouth handshake agreements with people, and it works for a little while, and then it doesn't. So here's a quote: the word has gotten out that DNR doesn't follow through, so people just ignore me when I try to get them to do voluntary enforcement. So if you can't back it up with a big stick, having a handshake agreement isn't necessarily going to work. And the field staff are finding that out, I think, the hard way. And it's something that needs to be addressed if we're going to have a healthy water common. So some briefly recommendations for going forward. I think we need to restore the Natural Resources Board selection of the Secretary of the agency, to remove the agency from the governor's cabinet so that we can minimize the amount of political influence over decisions. Reinvigorate the training for people within the agency. Secure more reliable funding. One idea that I threw out in my paper is to have a real estate transfer tax just on the riparian properties. So those are the properties that are adjacent to water. And then also have an owner's manual that the university and NGOs create for riparians so that these system dynamics are more predictable, something that is more accessible to private property owners so that they know what their responsibilities are and know what they're contributing to the system when they manage their land in a certain way. Fifth, and I think this is important especially for the people in this room, that we need more emphasis on monitoring water quality impacts of deregulation. So I went over some of those structural problems with Act 118 creating exemptions. We don't really know what the impact is of that. It seems like it's a bad idea to people who care about water quality, but we don't know in a systematic way. So having scientists structuring research projects around looking at the impacts of these exemptions would be hugely important to knowing whether or not that is a good idea. Maybe it's fine, and then we shift our attention to something else. Or maybe it needs to be corrected. And then lastly, the beneficiaries need to get more active. Everyone in this room needs to be more active in being aware of what's going on and being involved in enforcing the obligations of the public trust and making sure that the trustees are being accountable to the public. So with that, I think we have a few more minutes for conversation, and let's open it up for questions.
So can you unpack that last point for us a little bit, and specifically with regard to, so presumably if you sue the DNR for failing DNR resources, which you could say is actually jeopardizing the whole mission.
Yeah, that's a good point. No, I think, well, what the public has the ability to do is sue the riparian who is doing something that violates the law. So you're not suing the agency, you're suing the bad actor. The agency has decided not to take action for whatever reason, and the public has the ability and has the statutory authority to take action themselves. So it's not really going after the agency resources, it's supplementing. I'm glad you asked that question, because there is another approach about suing the agency, but that's not what I'm talking about here. We have one in the front, back.
So I expect you're familiar with the Wisconsin DNR's best management practices for logging, permitting. Are you familiar with that?
I'm not familiar with those, but I know they use best management practices for stormwater and different activities.
To presumably protect aquatic resources.
Okay.
And this is really important because any logging on federal land that is then, the EPA's jurisdiction, those guys defer. They permit these logging projects based on the Wisconsin best management practices. But the Wisconsin best management practices, I call them the worst management practices because they essentially are fraught with, as you were talking about this Act 118. They're just like that. They know what they should be doing or not allowing in areas that would affect the public trust of the aquatic resources, but they make exceptions. They say, yeah, don't log in riparian zone unless it's not practical. You got to do it, you got to do it. So there's just exceptions everywhere within this huge document. But I wonder then if that would be subject to this public trust doctrine, that whether beneficiaries could actually sue the logging companies that are.
Well, there you're taking issue with the best management practices themselves, and that would require a challenge to the agency that created the practices, or if it came out of the statute, a challenge to the statute. So that's a little different scenario than if there's a law on the books that a private person is violating. Yeah. But another aspect of that, I think that's important, is whether or not the impacts from the best management practices have been studied in a scientific way, and if there are peer-reviewed studies on that, because that could help build support. I mean, lawsuits are not the only avenue for creating policy change. And so building the body of scientific study on this and then using that to organize around creating new rules, if that's the avenue, is another way to address that. We can talk
The
more after.
evidence is there,
Too.
and I've challenged them, hundreds of challenges, that when they revise the best management practices, they ignored every one of them. They just revise the rules without my input. So, what's next?
Sounds like a larger organizing effort is needed. Yes,
Yeah.
Rick?
Take the mining issue. The legislature just passed a bill that basically said they have unavoidable impacts, that they're allowed to affect these wetlands and rivers and streams and other groundwater systems and try to mitigate it somewhere else by doing something else. Does the public trust doctrine say really the legislature can't pass a law that would allow water systems to be impacted, knowingly impacted? I mean, how does this play out?
So you were just listening to this for the past 45 minutes. What do you think?
Well, I think that there could be a whole lots of lawsuits that will say the legislature cannot pass such laws. But
Based on?
Public trust doctrine.
Based on its constitutional duty.
Yeah.
I mean, my work is done.
No, but we need good attorneys like you to
But
be
yeah,
out
if you
there.
convince us, that's fine, but then what do we do? I mean.
Yeah, there'll have to be a lawsuit brought to challenge that. The public trust doctrine is not self-enforcing, okay? I went through the core features of it. You know from that there is a legislative duty that's grounded in the state constitution. You know that from just sitting in this classroom for less than an hour. And yet, nothing is going to change unless someone actually brings a lawsuit to challenge the law that was passed in violation of that constitutional duty. If it's not challenged, it'll just go forward.
Is that state
So-
court or federal or?
State.
State, yeah.
So mine is actually similar to what he asked, but a little more specific, is in this new mining law, the way I understand it, they can fill in a water body that's 2 acres or less than 2 acres. And my understanding, before the public trust doctrine, what you said in the last few minutes, is that they can't legally do that. That's navigable water.
Correct. And if you think about the Monona Terrace, okay, that was a very small lake bed grant. This is kind of akin to a lake bed grant, what the legislature did. They're granting the entire lake to a private, one single private use. But they haven't gone through the 5-factor test that the Wisconsin Supreme Court has established that was used with the Monona Terrace. And they couldn't pass that test because the lake as a lake is destroyed. So part of that test is that the lake continues to function as a lake and that the public continues to have rights in it and that the project itself is open to the public and enhances public rights as the Monona Terrace was found to do. So you can see just from that, think about Monona Terrace compared to filling these lakes, it's just not compatible at all. So, yes.
I supervise some of those water management specialists, and I want to thank you for what you did. They're very appreciative of that. And there are nuances in your report that I would have some issues with, but other than that, I think it's pretty accurate. And we are increasing our training and things like that. I just let you know that we are doing some of that. But we used to have so many more people in the field, and at one point we were in the 40s, the high 40s of these water management specialists in the field. During our vacancies and full times and all, we got down into like 19. And you can imagine those folks were running scared because they'll make a bad decision in their quick turnaround times that they're required to have. And now we're back up. We hope to hire the last couple that will bring us up to 32, but that will be our permanent staffing for the foreseeable future. The last one I want to just mention is lake bed grants. Since this has come up, there are a lot of existing lake bed grants and bulkhead lines out in the public right now that were granted years and years and years ago that were never implemented. And there are now people coming forward wanting to implement them, including the city of Madison that would like to put a 2-acre fill just east of the convention or the Monona Terrace for what they want to call Festival Park. It will be our version of
Summerfest.
Yeah, Summerfest, exactly. And there's other ones out there that have made it to the paper. There's those kind of things are out there, and we're sitting with a legal decision that's on the books, granting them some kind of lake bed grant, saying staff are saying we've got to stop this, and others saying, but how are we going to fight something like this? And you can read between the lines on all that to figure out how we might not be able to fight.
Thanks for the updates on that.
So let's take the mining or any one of these. Who are the stewards? Not the storm sewers. But I mean, who steps forward? Like the tribes are thinking of stepping forward, but who else might step forward? Some of the NGOs? Certainly the DNR can't sue them.
Right. So technically, any beneficiary of the trust, so any person who uses the waters that are going to be affected by this could be a plaintiff in a lawsuit like that.
Do it, John.
So you have to have a use of that water body or a credible assumption that you're going to be using it sometime in the future that will be harmed. And that applies to anyone who,
But
goes
it's all
out there and
like
enjoys natural scenic beauty, or kayaks, or fishes, or floats logs.
So a lot of the NGOs have come out against it. The Nature Conservancy, in its mild way, has come out against it. The Rivers Alliance has come out against it, one after the other. And of course, somebody in this room is not going to do this. I mean,
Not on your own, not unless you own land up there and really feel, I mean, that's when you see people stepping forward as individual litigants, is when they have a private property.
But can a coalition of NGOs
Yes.
take them to
Yes,
court?
absolutely, so it's up to the, I mean, the NGO boards will have to decide whether or not they're gonna allow it to stand, but if you are a member of one of those groups, you can try to influence them, obviously, as a member, or you could come forward and say, hey, I use the water in that area, I'm a potential member of your group that's injured.
I'd like to go back also to the role of the counties and the cities. Like in this county, we have a Lakes and Watershed Commission, we have a large staff on lands and waters within the county, and they have staff that go out and enforce and look for the kind of things that you've shown along the shoreline. Now, where does their authority come from? Is it handed down or from this trust doctrine, or is it something they've just decided to do on their own, or is it?
I would have to look more at the details of how Madison has established that in Dane County to answer that, definitively, because each county doesn't have the kind of staffing and oversight that Dane County has. I suspect that's something that the county board and the city decided to enact on their own, and isn't something that's part of this state mandate under shoreline zoning or anything. But I don't know that for sure because I haven't looked at the details of that. If it were something that were state mandated, you would expect to see uniformity across the counties, that each county would have that level of detail, and I know we don't have that. Dane County and Madison really stand out as being aggressive and in their oversight.
I wonder if some of the state people here know how that authority is, whether it's independent or whether it's granted by the state.
Does anyone know? No? Okay,
Thanks.
there's one up here and then maybe in
Mine's related to your fifth point there and kind of the connections to science. You mentioned the impact of peer-reviewed articles on some of these cases. And I guess I'm wondering about water quality impacts of deregulation and some of these processes they're having at a watershed scale, and they're really difficult to prove, that it was deregulation or it was intensive rain events that caused a water quality impairment. So could you talk a little bit more about burden of proof that connected to science and what applies to the law?
it's hard to generalize about that, but I think that you get at something that is outside of my expertise in terms of how you would structure a study that would show, be able to identify that it's deregulation, and so now we've got these activities that are happening that previously hadn't been, and whether or not where you have the data, where you have the baseline from what existed before the deregulation. So I just don't know enough about the databases that are out there. That's for you guys to think about. What exists? What is that body of knowledge that exists pre-different changes? So take the mining law, if it stands. What's the body of science that exists right now as to the current state of affairs there, and how far back does it go? And then what would we need to study? What variables to show the impacts of filling a lake that's less than a certain size? And so that's a really important way, I think, to think about this mining challenge as well. It's not just, most people in this room, probably no one in this room is actually going to become a litigant to challenge the mining law. If you do become that, call me though, because I'll applaud you. But what you may realistically think about doing is how you would research this and document what's happening to assist the information development in the next issue that comes up, or in reforms that need to happen in relation to it.
So as a scientist, like I have contacts in the DNR where if I do a body of research, say, looking at the littoral habitat and how humans get onto that, I can shoot an article to them and be like, hey, this may be of interest to you. What is our role with the law? Should we be trying to make contacts with folks that our research may be relevant to, some of the lawsuits that they get involved in?
Oh, I think yes, definitely, and that's a huge area that I'm really interested in studying. Actually, is trying to figure out how scientists can get more involved in influencing policy and what the different avenues are for doing that, and what makes sense for science, what's comfortable for scientists and doesn't jeopardize your credibility and ability to speak objectively about the issues. So that opens kind of a broader research interest of mine that I'm excited about. But I think for you, you just have to answer that yourself. If there are legislators who are working on what you're researching, sending them information, it can't hurt. It can only help.
Okay, thank you, Melissa. Our time has come.
Okay.